Firstly, welcome everyone to this specially organised one-off webinar that's looking at a particularly thorny issue relating to holiday, specifically in relation to part-time or part-year workers that came out from the Supreme Court decision in Harpur and Brazel, or could be Brazil. I'm not quite sure which way we pronounce it, so apologies to Ms. Brazel if I got that wrong. For those of you that have been at the events we've been running for since about 2013, 2014 in London, back in the day when we did them in person and then latterly remotely, I'm Andrew Secker, I'm one of the partners. I've been talking about holiday pay for so long that when we had this put in the diary, unfortunately you got stuck with me because this is something I've been banging on about for a while. But to keep me in check and to make sure we've got some really useful insights, I'm delighted I'm joined today by Kate Watkins, one of our principal associates.
Thank you, Andrew.
What have we got for you today? Well, just a couple of housekeeping rules. So we are online. It's a webinar. I hope your tech is working. I hope our tech holds throughout, but anything can happen. We're recording this, so if something does happen to your tech, do drop Kate or I a note and we'll make sure you get a copy of the recording. We've got you for 45 minutes, and we think that's enough really to dive into this decision and to look at what it practically means. So on the slide we've kind of broken down how we're going to do today's session. So I'll set a bit of the context. Then Kate's going to really dig into what actually happened in this particular case, and then I'll start looking at, well, what does it mean in practice? And then we'll drill into, okay, which people within your workforce does this decision affect? Now, I'm conscious that we're going to have a large number of people who work in a range of different sectors joining us today. So we've kind of done this session so it's sector agnostic. And we're going to be talking about how this case applies in general terms. I appreciate there may well be some specific questions that you might have that might be relevant to your organisation or the particular type of sector that you work in. But at the end, what we're going to try and do is leave enough time to pick up some questions. We've got a starter for, I would say 10, because that's kind of what you say, but it's actually a starter for 5. So we've got 5 questions which we think are questions you're likely to have had. Hopefully our crystal ball is working rather well on that. And then we'll keep an eye on the question and answer function to pick up any other questions. So just to be clear, if you've got questions, we'll try and pick them up, but do you click on the question and answer box, type in, and then we'll keep an eye on it and we'll do it at the end. So that's what we're going to cover for the next 45 minutes. And with that in mind, I'll just pause and we'll kick off and look at the background. So holiday pay, as I said, we've been talking about it for a really long time. For me, I think to understand the true impact of this case, we just need to step a little bit back to then go forward. So forgive me for teaching you to suck eggs, but essentially the working time regulation, so the set of law which is affected by this decision, implements the working time directive. I know we all know that, but the key principle that's come out in a number of the historic cases about this is that one of the primary purposes of the right to paid leave is to rest, to recuperate, to take a complete break from work. And I think it's important to understand that context in trying to understand why law that's effectively granting people time off is being interpreted in a particular way. There's also 3 really important building blocks to try and get your head around how this decision came about. So building block number 1 is that working time leave, so that's the 5.6 weeks leave granted under the working time regulations, has always been calculated and expressed in a week. That's why it's 5.6 weeks. I know that most employment contracts for full-time or full-year employees often expresses it in days. That's how we all do that from an employer's perspective because it makes sense, but it's always been expressed in weeks. Second building block is that the way in which we calculate holiday pay under the working time regulations is also by reference to a week's pay. There's a set formula that that's linked to the Employment Rights Act, which calculates an average of your week's pay over a reference period, and there are different rules depending on whether you're salaried or variable hours and various other aspects of it. So building block number 2, the amount that you pay is based on a week's pay. Final building block is that, in essence, the leave that you have in each holiday year doesn't accrue according to the number of worked weeks, with one exception. And that exception is in the first and last years of your employment, when the holiday you accrue is effectively 1/12 for each month worked in the holiday year. So just bear in mind those three building blocks around how much leave you're given, how pay is granted, and how it's accrued. It's also worth saying that there's been enormous amount of litigation around holiday pay. So that includes the case of Robinson Steele, which said that rolled up holiday pay, so that's where you aggregate holiday as a part of your overall remuneration, is unlawful. And Kate's going to talk about a practice whereby people have been allocating a specific percentage of pay as it accumulates as you for the hours you work, which is probably not right, but was adopted by a number of people just because it was practical. We then had cases like Best Scotland, Lock and British Gas, which dealt with the extent to which, when you're calculating a week's pay for those with variable pay, you have to include elements like bonus, overtime, commission, various allowances. And then we had a bunch of cases which looked at the additional circumstances that are not written into the working time regs about when you can carry forward working time holiday. So those were principally around cases involving ill health or maternity or similar leave. So quite a lot of backdrop to that. And that's why you've got so much complication that employers were looking at ways to simplify how you calculate what leave is accruing, particularly when you've got the growth of things like the gig economy and part year or different forms of working. So I think that neatly takes us on and segues to the specific case in Harpur.
So what happened in this particular case? For those who aren't aware, I'll just run through some brief facts of Mrs. Brazel's particular circumstances. So she was engaged by the Harpur Trust as a music teacher. She was on a permanent contract, but only worked in their term time. She was paid for the hours that she worked, but the crucial point is she had no regular hours. So what she worked each particular term depended particularly on demand for her to go in and teach music to those particular students. So her hours were different every week of that term, depending on that particular demand. The trust had previously calculated her holiday pay based on what people will hopefully be familiar with as the working time regulations position of the average of 12 weeks before her leave. So what was the average of the 12 weeks that she worked before she took her particular holiday? And you'll be aware, hopefully, that in April 2020, that average of 12 weeks actually increased to the 52-week period to reference the calendar year. The trust changed the way that they approached the calculation of her holiday and pay to what's commonly known as the percentage method, so the 12.07% of hourly pay. And where that's actually derived from, for people that aren't aware, is if you look at the 52 weeks of a typical year, if you take off what is the statutory minimum holiday entitlement of 5.6 weeks, it leaves you rough and ready figure of 46.4 weeks of the year in which a standard full-time worker would be working. So 12.07% is the concept that a full-time worker is effectively earning their holiday entitlement at 12.07% of the hours that they're working. At the time that this case was being pursued by Mrs. Brazel, the 12.07%, the percentage method, was actually an ACAS recommendation to ensure that casual workers like Mrs. Brazel, who had no regular hours, was accruing her holiday in an equivalent manner to a full-time worker. So the 12.07% was effectively a way of ascertaining what was the holiday that she was accruing for the particular hours that she worked, bearing in mind that her hours weren't regular hours across any week. It fluctuated based on demand. The problem is that the working time regulations didn't reference 12.07%. As I've said, it was complete common practice across the board. It was an ACAS recommendation that was very quickly repealed from the internet and all of their guidance once this case was going through the Supreme Court. So Mrs. Brazel challenged the method of calculation being used by the trust and believed that her working time regulation leave, the 5.6, was being underpaid for her. So why she challenged those sums, if we just have a look at some of the calculations. So Mrs. Brazel was deemed to take her holiday in school holidays, natural position in the education sector that would be the case. Her holiday was therefore split into 3 tranches. So her 5.6 leave, divide that by 3, gives us roughly the 1.87 weeks is what her holiday was deemed to be when she took it. The judgment in her case looked at the example of a spring term and applied both the historic percentage method, the 12.07%, and compared that to the working time regulation averaging method. And if I just talk through sort of the example on the slide, which is what came out of the judgment, it will hopefully make things a little bit clearer. So in the spring term, using the percentage method, looking at that spring term, and there were 10 weeks in that spring term, Mrs. Brazel worked 127 hours. So the trust applied her 127 hours, applied the 12.07%, and they determined that she therefore had 15.33 hours of holiday. Her holiday had accrued through the percentage method based on the hours that she'd worked in that previous term just before she took a holiday. Helpfully, she was paid a fixed hourly rate of pay of £29.50. So applying that to what they determined her holiday hours to be gave us that sum, or gave the court the sum of £452.30. If we look at the way that Mrs. Brazel was saying it should be calculated, you can see there's a difference of about £234. It's not a significant sum, but obviously in this case it's important that the working time regulation method and averaging her actual hours and pay gave a greater sum. So rather than looking at, in that spring term, she worked 127 hours, they looked at the court said they should look at the last 12 weeks in which she worked, discounting any weeks in which she didn't do any work. And actually her average therefore was 149.5 hours, not 127. And so what that means in terms of the complication then, the figure underneath in terms of working out, well, if she did 149.5 hours and we times that by her hourly rate of pay and then divide it by 12 for the 12-week point, that gives us the rate of 367.52. If we then times that by her 1.87 weeks of holiday, you get the £687.26. So don't worry too much about the numbers on the screen. I think the important thing to take from that is obviously using the percentage method, it was looking at the 127 hours in that particular term, using the working time regulation method and looking at the last 12 weeks in which she worked, you've already got a higher figure in which you're starting from your calculation point, because on average she worked more hours and therefore ends up with more holiday pay because of having worked those additional hours when looking at the working time regulation averaging method. So what did the Supreme Court say about both of those particular ways to calculate her holiday? So they effectively said that the 12.07% multiplier is incorrect. They rejected it as a way to calculate somebody's holiday. And what they said is that if that is being used by employers, it should stop, hence why ACAS removed their guidance. We do come on to later whether it means that you can't use the percentage at all. But as I say, the position at the moment from the Supreme Court is that applying the 12.07% is the incorrect method for calculating holiday. They said that part-time workers are still entitled to the minimum working time regulation entitlement of 5.6 weeks leave, and that should not be prorated down for people who only work part of the year. So it shouldn't be you shouldn't discount any weeks in which they've not worked and say, well, you haven't worked for the full 46.4 weeks of the year, and therefore you can't accrue the same amount of annual leave entitlement. They said that pay should be calculated in accordance with the working time regulations. And what those say is that pay should be based on average pay over a reference period. We know that the reference period used to be 12 weeks, it's now 52, and that you ignore any weeks in which there is no pay. Hence why when we looked at the two examples with Mrs. Brazel, when we looked at her previous 12 weeks and discounted any weeks in which she hadn't worked, we actually ended up with a higher sum because it didn't discount the weeks that she hadn't actually done any music teaching for that particular school. So for Mrs. Brazel, it meant that the calculation had to reflect her annual workings during annual earnings during those weeks that she had worked. The decision, it's important to be aware of, only applies to working time regulation leave, so the 5.6 weeks of the year. It doesn't mean that it applies to anything contractually that you may give in excess of that. What it would then mean is obviously you could end up with a payroll headache of having to work out holiday in two different ways if you decide to treat your contractual leave over and above the working time regulation leave in a different way, whether that's for ease, administration, cost. It could just be that you have sort of that two-tier system. And it doesn't mean that you can't determine when that holiday is taken. So the trust were okay to still dictate to Mrs. Brazel when her holiday was deemed to have been taken, provided they gave her the requisite notice to inform her that she had to take that leave then. What the judgment affected, and as Andrew will come on to in terms of the impact, is the way in which her holiday was calculated, given that she didn't work for a lot of the year because she was a part-year worker. And the Supreme Court, in a nutshell, said that doesn't matter. She will still accrue holiday and be paid for the same way that effectively a full-time worker would do that.
Yeah, and I have to say that what's really important is to try and work out what this case really does mean. And for those of you that know me, you'll be unsurprised that when this decision came out, what I did was, printed it out, found a quiet moment to read it in detail. And like a lot of people who've read this decision, the first time you read it, I was slightly underwhelmed by it. And I couldn't quite get my head around it. And I was thinking, well, what is it that I'm not understanding? Why is this not made legal sense to me? But the morale sense was kind of clouding my judgment. And saying, I don't quite understand how we've reached this. And then kind of I had my sort of light bulb moment, or perhaps moment of clarity. And that's when I realized that what this decision is really trying to tell us is that you have to divorce the idea that the accrual of working time holiday is linked to the hours that you work, because that's essentially what the percentage method was doing, is kind of saying, well, look, you're accumulating a pot of holiday pay and therefore your leave is kind of accruing in proportion to that. Well, that's not actually what it is. You're entitled to 5.6 weeks holiday in any holiday year if you are a worker or employee, and actually that's your blanket entitlement, and you have to divorce your amount of leave and then what you get paid, because that's where the averaging comes in to it. So it's an average of the 52 weeks worked prior to the date you take holiday. It's also important to re-emphasize that this decision was all saying, look, working time holidays, back to that principle, it's about a week's leave. It's not about days or hours, which is a real problem, I think, for employers, because the growth of atypical working, 0 hours workers, the gig economy, all of these things have led to some really enterprising use of different labour models. And this decision, which is emphasising this concept that we work a week, is slightly arcane in some respects, because it kind of doesn't make sense with the way the modern world of work is going, but it is in line with the working time regulations. And we'll come on to look at, well, hang on a minute, how does that leave the question of accrual? The other point that does come out, and this was in the Court of Appeal aspect of this case, so before it went to the Supreme Court, is there's some fairly stark examples of what this case would mean. And like any good webinar, we're kind of looking at the extreme example. It's the one that's been in quite a lot of the legal press. But the example given in the Court of Appeal was that if you had an invigilator, so someone that was engaged on a permanent contract, but actually you only got them to work during a single term, and they worked for a week, you paid them £1,000 for that. This decision means that they're entitled to 5.6 weeks holiday in that holiday year with a notional pay of 5,600. So that's why we're all thinking this decision was bonkers, because we're saying that someone that's only working for a week who gets paid £1,000 is actually nominally entitled to 5,600 worth of holiday pay. Which then brings us on to the practical question and sort of what are the exceptions to this? Well, as I said right at the outset, and there's a method to this madness. That's why I was talking about building blocks at the outset. Your holiday accrual in the first and last year of your employment is something that prorates as you go along a holiday year. So that's a 12th for each month that passes. Secondly, and keep with us on this one, the pay that you get upon termination can, for leave that's accrued but untaken, is calculated on termination in two ways, either by written agreements, that's under the terms of the contract of employment, or there's a set methodology under the working time regulations which calculates the proportion of holiday you've accrued relevant to the holiday year at the point of the contract terminating and the amount that you get paid. Now, what does that mean? Well, what we're talking about here is that if someone's engagement starts and ends in the same holiday year, and a great example of this could be actually you simply engage an invigilator for a single term. The holiday that they would accrue would be prorated, and if their engagements ceased in totality at the end of the term and you paid them in lieu of what they accrued, that's something you can determine. So it's really trying to focus on who could be caught by this, and actually what it kind of means, and we'll come on to this moment as who, it's kind of a nod to the categories of people, and it's often, as Kate can come on, about those who are permanently employed. And this has come up in the question and answer box. Another point to stress is this is not covering holiday in excess of the working time leave. As Kate said, there is it's all great in theory saying, aha, this decision doesn't apply to your holiday in excess of the working time leave, which is somewhere often between 5 and 8 days, depending on what your entitlement is. So whether it's 25 plus the bank holiday or slightly more. The whole practical question of, can you operate two systems, or how does the offsetting provision, if actually you pay one set and another, that's a practical headache that just needs to be worked through. So really important to think about this in terms of, okay, so it's really affecting the entitlement of holiday and divorcing what and what you work from the amount you accrue. Okay, so Kate, I think it then naturally follows to say, okay, well, we've had that wonderful explanation, Andrew. Who does this actually apply to?
Thank you. And I think the common question that we get, and I think from what I've just briefly seen in the Q&A, is people thinking, okay, well, if you look at Miss Brazel's situation, does it not therefore only apply to people in the education sector who are working term time only contracts? And the answer is no. So as Andrew said earlier on, it applies to any workers or employees who work under permanent or continuous contracts, who have irregular hours, and who effectively only work part of the year, but then aren't paid for the full 5.6 weeks holiday. So the classic situation, and I think to answer a number of questions in the box, is it will apply to 0-hour workers or employees where they are engaged on a permanent contract, and we'll come to that as well through some of the Q&As at the end. It can apply to bank staff, it can apply to term time or seasonal workers, so people that you might engage particularly at the Christmas period to help with peaks and troughs in work, if they are engaged on a permanent contract that maintains throughout the rest of the year. So it does apply far wider than just Mrs. Brazel's unique situation of being engaged on an all-round year contract, but then only working particular terms. It can apply to a much wider population of people, and the classic example being those engaged on 0-hour or umbrella contracts across the whole year. And obviously, looking back at Andrew's example of the invigilator with the £1,000 and then 5,600 holiday, the higher the number of non-working weeks, in reality, the greater the holiday pay is going to be, because of looking at, in that example, you have 1 week of work across the whole year. It means that when it comes to looking at any sort of average, you're literally looking at that, that pay they've received, and it gives sort of that distorted, on first glance, that distorted figure, and seems, a bit of an unfair position when you compare that to a full-time person who isn't going to get that for their holiday. It's probably a point worth mentioning that was bandied around in the Supreme Court, and the Supreme Court rejected that as a reason not to go with their decision, because they said those anomalies will hopefully be few and far between. But ultimately, the law as it stands at the moment is set up to make sure that part-time, part-year employees are treated not less favourably than full-time people. It doesn't therefore mean that you should make sure full-time are given sort of the equivalent uplift. So it does seem, if you're thinking at this stage, it seems a really strange decision, then it seems like you're probably following, because that is where we get to with it.
It's that weird point, isn't it, Kate, that actually you've got this averaging of pay which takes into account only the weeks you work. So it assumes you've worked 52 weeks, but actually you're then granting leave in a year where you've not actually worked those weeks. So it's that sort of dichotomy between the averaging of what you get paid and then sort of the reality of what you actually work.
What you actually worked for that. And the complication comes from all of this through when looking at, and I think, again, this was one of the questions, and as Andrew just said, it might be clear how to calculate a week's pay, and I say clear but not easy, because you're looking at the 52 weeks, the average over that 52 weeks that they worked. But where this case leaves us, just in terms of holiday entitlement for part-year workers, is it doesn't give any guidance. Okay, it tells us how to calculate the amount of a week's pay, but how do you calculate the amount of leave where somebody wants, given what Andrew just said about holiday is accrued in weeks, not hours or days, and that's what this judgment leads us to. How do you calculate it for somebody who just wants a day off? If my day as Mrs. Brazel fluctuates between 2 hours 1 week, 3 hours the next, what is a day for me? What does that actually mean? The government have produced this guidance, and we can send a link round to that if people want it, around how to calculate holiday entitlement for those on different types of contract. And they talk about this. Well, you may wish to calculate it based on average days or a representative reference period, and then goes no further. So kind of floats that idea around in terms of, well, there are some options as to how to go about calculating that, but kind of over to you, employer, to do that. So you could look at what is an average working week. So you may look at Mrs. Brazel and say, well, her average working week across the year, or looking back, was 2.5 days a week was roughly on average what she tended to typically work. But then that leaves that awkward, complicated calculation of, well, what does a day then amount to? If a week on average is 2.5, is a day therefore 0.4% of that? And what sort of calculation do you get to work out an average day for her? There's then the question of how often do you have to keep looking at that to work out, or is that average working week still relevant? Is it still appropriate for her? How often do you have to update that? Can payroll administer that kind of calculation? So I think sometimes where we get to with looking at the government's suggestion of work out your own representative reference period is the legal risk, the admin involved, whether payroll can actually do that. And what we come on to is sort of some of the Q&A that we've had through this from clients that hopefully will answer some of these questions as well as to how to go forward with it. But I think at the moment, the situation in terms of how you calculate a day's leave or part of a day's leave for people like Mrs. Brazel is still a complicated situation to find yourself in, when all of the references to holiday is based on a week's pay and a week's leave.
Yeah, and I think that's going to be the really interesting bit, because kind of the decision is kind of saying, look, if they get 5.6 weeks and you've paid them the right sum, then it's kind of, they've kind of just left the point of, does it matter how much leave they're actually taking in a week if actually their pay is correct for it? But I think we know there's some practical problems here. Okay, so let's just finish off before we get onto the Q&A by thinking about who is not affected. So first thing is that, look, this doesn't affect those who work part of the year or term time only, whose hours are regular and therefore their salary is inclusive of their holiday entitlement. So what I mean by that, I know there are a number of term time people who have their holiday designated during the school year, but if they're paid an annual salary, they have fixed regular hours and their pay is consistent throughout the year, and effectively their holidays, 5.6 weeks holidays incorporated in their rate of pay. This decision is not affecting them. And it's important, Ms. Brazel, worked irregular hours and kind of worked at different times, so her pay significantly varied. So actually, they weren't they weren't paying her an annual salary that was inclusive of her holiday entitlement. The second thing, and this follows from a couple of points that both Kate and I have been mentioning, and this is relevant in terms of the way in which you're engaging probably your worker community. This decision won't catch people who are paid for single one-off assignments. So a great example of that is Kate's one about someone that's engaged in a retail organisation to work over the festive period. If you remember that time we went to shops rather than just bought everything online. But yeah, someone could come in there, they come in, they work for a couple of months. At the end of their assignment, they're paid for their accrued but untaken holiday. It goes back to this point, the first and last year of employment, holidays accruing at a certain rate, and you can pay on termination in accordance with the method set out in the contract. So this won't catch those people. It's really catching people that are engaged throughout a holiday year period. And the final thing, and probably obvious point, is this is not applicable to full-time workers or employees because actually it's quite clear how you calculate their holiday. It's easier for them because there's not that many working weeks they don't work. So that's kind of who isn't affected. I hope that's sort of fairly clear, because it then leads us quite neatly into some questions. So these are the 5 questions we came up with, trying to pick the main areas that we thought we might have questions on. Now, I have to say, we've done a load of webinars during the period since March 2020. I've never seen so many questions. We've got 38 at the moment. So let's try and deal with these 5, and then we'll try and pick up a few that we can. So the first question, and I think this has come up quite a few times, is can we still use rolled up holiday pay but use a rate higher than 12.07%? Now, the percentage method is kind of not right, but but it was traditionally seen as okay. And the reason for that is that under the working time regulations, you should really get paid at the time you take your holiday. But where you pay someone a designated amount for holiday pay, that kind of offsets and reduces the amount that an individual can claim in terms of underpayment of holiday. So in other words, as long as you're paying someone correctly for their holiday pay, if you went to an employment tribunal and said, look, I've not been paid holiday, and they said, well, actually, you've got your percentage method, so it made no difference. The claim's not worth any money. So then that begs the question of, okay, well, if in theory you could come up with a percentage method that gets you to the same place that is a little bit higher than 12.07, should you do that? And I think there's a few considerations. So firstly, there's the maths. Can you come up with a different calculation? How does that fit in, with your overall employee relations profile? Because it might mean that you're paying those on this type of contracts higher than you are for full-time employees. Is that a problem? The courts have said quite clearly that these cases should be few and far between. There's a reputational thing. We are in a world where ESG, governance, reputation, very, very important. Do you want to adapt a policy which we know the courts are saying isn't the right thing to be doing as on a technical point? But also we've got to bear in mind the administrative burden of trying to work out how much holiday people accrue and get paid for across the year. And we know that from all of the holiday pay decisions on Bear Scotland about how you calculate variable pay, that has caused a massive administrative problem for employers that are looking at all sorts of innovative ways of saying, well, I can't quite do it completely in line with what the working time regs do in this way, but I might come up with a different methodology that gets employees the right holiday pay, but we might just take some slightly different approaches in how we do it. So I think the answer is, in theory, yes, you can come up with it. The question is whether should you and how do you do it? Kate, do you want to then think about, okay, do we need to change terms and conditions for any part-time staff on the back of this decision?
Yeah, and so as Andrew has obviously said, if somebody's part-time but works regular hours, they're still going to accrue their 5.6, but they're, let's say that I work Monday to Wednesday. A week for me is Monday to Wednesday, so I would still get 5.6 weeks worth of Monday to Wednesdays off. So I think it's important to keep bearing in mind that we're talking about those who, may work part of the year, may work part-time, but have these irregular hours where you can't actually determine what a week's leave for them may be. So do you need to change their terms and conditions? Classic lawyer answer, it depends. So some contracts may still refer to the 12.07%. And, we're not necessarily saying that you need to go ahead and remove that. It may be the case that that's where you get to on the back of your sort of internal risk analysis, because there is the element of, wait and see, that there may be that trade-off internally of, what is the right thing to do for us versus what the risk is for us, versus actually if we run the percentage that Andrew just suggested and it already gets us to say 13%, it's, it's more of a minor amendment than actually removing something entirely from your contracts. But I think sort of the bottom line to bear in mind is that if your contracts and you are continuing to work it out on the 12.07% method, is to be aware of that risk and, to reflect on if your T's and C's do currently refer to that, almost applying a similar example calculation to what we did earlier on in this webinar, is to work out what the impact of that may be for some of your staff, and perhaps just take a population to have a look at what the impact may be and then make that decision from there. But I think, if your T's and C's do currently refer to the 12.07%, it may be something that you wish to amend and reflect on given the risk that's arisen from this case. But it's not necessarily the case that you now need to go through and amend everything sort of as a distress to the back of the case and sort of tweaking things that you might otherwise have left. So I think that, there are various options available to you, but there is the potential that you will need to amend that in contracts. Then
a broader question, and it's similar to the question that some people asked when they were trying to get their head around, well, we're now having to include elements of overtime in the way we calculate variable pay. It begged the question, what were you doing that generated the ongoing need for overtime? Can you look at changing that? Well, the natural position that comes from this case is, well, if this decision is catching people who engage throughout a holiday year but work only part of the year, can you engage them for gigs, so a job basis, so that each gig, the new engagement terminates, you pay them in lieu of what's accrued based on what's the rate set out in the contract? Well, yes, that could be one thing you do, but I think one's got to put this case in proportion. The growth of these types of workers, where they are engaged permanently and are called on as needed, is to meet a business need. So what we've got to avoid is reacting to this decision in a way that prevents this type of workforce doing the work that your organizations need. And my concern is that if you moved all of your, let's say, 0 hours workers who are engaged throughout the year to people who are engaged for every single assignment, well, what does that mean for your onboarding process? How does that affect any mandatory checks that either you have to do as a matter of law or you've promised to do to your clients or other organizations or things that people you contract with? How does that affect your delivery? Does it mean that people are less likely to work from you if actually they're not permanently engaged, so therefore they feel less connected to the organization? And in reality, if a lot of the people are engaged and do work on a regular basis, quite frankly, how much of a hassle will it be every time you're going to write them, go, hey, Kate, you did that assignment for us last week, brand new one, here's the same contract, can you sign it, return it, happy days. So I do think we've got to look at this in proportion. And I think you need to look carefully at whether moving to a job by job basis actually reflects what you need this particular group, the people affected by it. Does this affect how you're going to use and deliver services using that particular grouping of employees? What about historic underpayments and of holiday, Kate?
Yeah, so claims for holiday pay based on unlawful deduction from wages are still subject to the 2-year backstop that people will have been aware of on the back of case law back in 2014. So any claims in relation to historic overpayments are still subject, in Great Britain at least, to that 2-year backstop. We can also still, you can still take advantage at the moment of people may remember the Bear Scotland ruling that said a break of 3 months or more between payments could break that chain of deductions. That has been challenged in other cases more recently, so I think it's probably ripe for overturning pretty imminently. But at the moment, it is still good law to rely upon that. The 3-month break in payments could break that chain of causation with underpayments. But I think the broader principle to bear in mind is that 2-year backstop. It doesn't obviously mean that liability is necessarily decreased if they're significant sums we're talking about, but hopefully it gives a bit of comfort to sort of not to be thinking we're having to calculate for years and years beyond. I think the bigger risk actually is if you've got people who you have incorrectly thought were freelancers or independent contractors, because in some circumstances they have more right to actually carry over that leave indefinitely and bring broader claims than what just we're talking about with the 2-year backstop.
Okay, so just conscious we're coming up to our time. So the most important question, some people will be saying, well, hang on a minute, this is really hard. We really just need a simple thing saying holiday accrues in this way and you get paid in this way. So is the government looking at this? Are they proposing to amend the working time regs? Well, not as far as we know right now. It's clearly an issue which I think the government should look at. And with the ability to move away from certain European concepts, they've got a bit more freedom than perhaps they had done previously. So one would think that if you are anywhere near sort of Department for Business and Innovation, do lobby on this point, because I think just some simplicity, because I don't think it's a controversial principle that people are happy with 5.6 weeks leave. What we want is certainty as to how you calculate it and how it accrues across a year, absent any provision in the contract, and particularly in the concept of gig economy, this lack of clarity as to how you accrue leave, when you're working various different hours in different weeks. It's just a practical headache when there is just nothing in the regulations which sets out how that might work. Conscious, Kate, we've got time. Have you spotted a question we might be able to answer?
Yeah, I think there's a few questions that are picking up on your invigilator example, and I think there's a few that flow through the same theme, and therefore coming on to your point about job by job contracts. I think there's a few questions that pick up on this concept of, would the invigilator have therefore, if he or she was only engaged for that particular assignment, and the rest of the year wasn't engaged on any particular contract, would it have been the same situation? And that's to your point of job by job contracts, is that what we're talking about are those that are engaged on sort of the umbrella contract concept.
Yeah.
So had the exam invigilator, to your point, been engaged for that week's worth of exam invigilation and then employment terminated effectively at the end of it, we wouldn't have found ourselves in that situation. But that's to your point, as an exam invigilator, you would likely be doing enhanced DBS checks if it's in a school, and therefore you've got to balance that with your onboarding process of, is it and also from an ESG perspective of, we're trying to move towards a more flexible working practice, and what I'm sure the government didn't intend was for employers to start just having those one-off contracts that are ad hoc throughout the year and give people a bit more certainty that they're on an umbrella contract. So I think there's been a few questions to say, if they're not umbrella across the year and they're just engaged on those particular assignments, is the situation different? And the answer seems to be yes, it would be.
Yep, that's right. And you're absolutely right to pick up on. I don't think this is what the government would necessarily want, because you look at the traveller direction from the Taylor report and various other things, and the view of the certain groups within the gig economy having less legal rights than others. I think what we really want is just a little bit of certainty as to how holiday accrues. That's kind of the missing part of the puzzle, which is where the government probably should intervene. But we've not heard anything as yet.
No, I think the other question I'd spotted a few times repeated was around the impact of this on overtime when it comes to calculating holiday. And I think it's important to point out that all the previous decisions you'll be aware of with overtime, commission, bonuses, the same principles apply that were, borne out through that case law in terms of, is it regular, is it voluntary, is it guaranteed overtime? All of those same questions that we'd grappled with for all those years aren't impacted by this decision. What this decision is talking about is the accrual and the pay, but on top of then assessing pay, you are still going to have to look at things like, has there been regular overtime? Have there been sort of shift premiums that we need to take into consideration when calculating that average over the 52 weeks?
And there was also a point about those people that who are salaried staff and who work additional bank hours. It's the same sort of issue, which is this case really won't affect their accrual of leave. It's about how much you pay them. So again, it's going back to those Bare Scotland principles. So people who kind of have multiple income sources, they're just a variable hours worker, so your pay gets calculated differently. I'm just conscious of time. We've still got a few people. We might just I think just have a quick check to see if there's any other question that we can answer while we've got so many of you here. That there's been a question about the extent to which it's okay to pay rolled up leave as long as we show it on a separate line. I think hopefully we've covered this concept that allocating a pot of money that you say, okay, or a percentage of your hours that you say, okay, for each hour work you get X percentage of pay that we put into a pot for holiday pay. It still kind of gets you there in the long run, because although it's not right, you get credit for it if there were ever a dispute. The tricky thing, I think, is that it's unlikely that 12.07% is the correct one. So how do you come up with a percentage that actually is right? You could go safe and run some calculations and make sure you have an amount above that. But I think if you go through your risk analysis or your, the factors to think about whether you should be doing this and say, well, that might work for our organization. You might have a small number of people on this type of contract, and you're thinking about practicality. I think the devil is really trying to crunch the numbers and work out what the percentage would work for you. But I do think there's a range of other factors one has to consider before continuing with that practice. Well, I think that probably naturally brings us to an end. I just want to say thank you for all of you that were tuned in. We've still got 330 of you still with us, so thank you very much for joining us. Hope this has been useful. Do make sure that if there's as you leave and there's some feedback, please do pop that in. These sessions are improved by the feedback that we receive, so thank you for taking the time to do that. And on behalf of Kate and I, thank you so much for joining us, and we'll see you soon.
Thank you all. And as Andrew said at the start, we'll share the slides and any of the links that we've discussed. I think we've got, we can keep a copy of the questions, and, where they're not anonymous, we can seek to follow up where appropriate. But thank you, everybody.